Ready to proceed.
Good afternoon, Your Honors, and may it please the Court. Lauren Willard on behalf of Appellant Jarius Brown. Jarius Brown was brutally and unjustifiably beaten by several DeSoto Parish police officers. If he were located in almost any other state in the country, he would have been given the opportunity to litigate his federal civil rights claim. Louisiana, however, is tied with just two other states as having the shortest residual statute of limitations in the country at a single year that was applied to dismiss Mr. Brown's claim. This case presents the very question the Supreme Court explicitly reserved in Owens versus Akori, whether a one-year state limitations period is too short to be consistent with the federal interest of Section 1983. And here there are at least three reasons why application of Louisiana's limitations period of 1 year violates the well-established and undisputed rule that courts may not apply state statutes of limitations that are inconsistent with the federal interest of Section 1983. First, the application of the 1 year Louisiana statute of limitations violates the directive of the Supreme Court in Burnett to take account of the practicalities of litigating a Section 1983 claim. Second, Louisiana's residual statute discriminates against federal civil rights claim by providing less time than an analogous claim in state court. And third, both the action and inaction of Louisiana's legislature demonstrates a hostility towards Section 1983 claims. Notably, Louisiana extended the limitations period.
What do you make of the fact that there are other federal laws that accept 1 year's limitations? Doesn't that suggest that the federal interest is really not destroyed by a 1 year limitation?
Well, if Your
Congress
Honor's
is comfortable with 1 year in other.
Yeah, if Your Honor's referring to the 1 year statute of limitations in Section 1986, I think that's not relevant here for several reasons. First, that was part of the controversial Sherman Amendment to the Civil Rights Act, where in order to get passage, they needed to narrow the application of Section 1986 with that 1 year statute of limitations. But if you understand if you understand that in context with 1983, Congress did not include that narrowing Section 1 year statute of limitations in 1983, and under statutory construction, expressio unius, you would not find that 1 year should apply to 1983. And remember, 1983, that's the core private remedy for federal civil rights claims that the Supreme Court should sweep as broad as its language.
So I appreciate what you're saying as a purely textual matter. Your expressio unius argument, I actually think has quite a bit of force. I guess, though, at the end of the day, we're bound by the precedent. As you noted, we're limited to just that reserved question of federal interests. At the end of the day, if the federal interests aren't frustrated by 1 year, at least in that context, I'm trying to figure out why would the interest be different to the point where we as a court can step in where normally Congress would write?
Yes, Your Honor. So when you're looking at whether the 1 year in Louisiana is inconsistent with the federal interest, there are a number of reasons here that's separate from looking at the 1986 context more generally. So here in Louisiana, you have the 1 year, it fails to provide sufficient time, but that's coupled with the evidence of discrimination and hostility by Louisiana's legislature and the fact that Louisiana itself recognized that more time is needed for victims of violence and abuse by extending the state limitations period that applies to those victims when the defendant is a private actor, but not under Section 1983 when the defendant's a police officer or a state official.
When you say there are three reasons, they're all interrelated or each is independently sufficient? And I ask that focusing on the third, you're saying Louisiana's inaction. Is that because several states also used to have one, but some of those states have now retreated? In other words, you began by saying just had this happen in all but what, two others?
Correct, Your Honor. This is Louisiana and two other states are the outlier as only having a 1 year residual
So it's
statute. Kentucky and Tennessee.
And also Puerto Rico.
And also Territory of Puerto Rico, although D.C. has a 3 year statute of limitations. But I think there are 47 states plus D.C. that have 2 or more years, Your Honor. But to your first question, I think they are independent grounds. However, the combination of the three makes it particularly clear here that it's inconsistent. And so if the court chooses to narrow its holding, I think the combination of the practicalities with the discrimination distinguishes our case here from the 1986 context, from some of the cases cited by appellant.
None of, was it the Sixth Circuit and the, who else would we be looking at?
The First Circuit for Puerto Rico.
Neither of them have spoken to the footnote 13?
Correct. Neither of those decisions have addressed this very question of whether a 1 year statute is inconsistent with the federal interest of Section 1983 because it fails to provide adequate time or is discriminatory.
They haven't. But the Ninth Circuit did post Owens.
Yes, Your Honor. The Ninth Circuit and the 11th Circuit both have, in short, opinions that addressed it, but not in the police brutality context. Those were both property-related claims. They didn't really get into the practicalities that we've raised in our briefs. And both of those states,
Your
as
argument
you
really
recognize,
is
have
focused
repealed it.
on the police brutality specification. To win, we've got to say no. In other words, and you see the difficulty with that. Wilson, is it, and Owens both were police brutality cases.
Correct.
Yet the court didn't parse it out. They said we need a uniformity here, general limitations work.
Correct, Your Honor. So because Louisiana's one-year limitations period fails to provide sufficient time for important claims, police brutality and misconduct are at the heartland of what 1983 is intended to remedy. It must therefore be inconsistent with the federal interest of the statute more broadly. So, and more importantly, I think, or relevantly, is that the types...
I want to hear why it failed, why you contended it fails to provide sufficient time to bring the claim.
Yes, Your Honor. There are a number of reasons, as we've articulated in the briefs, and the Amici have as well. So, first, victims of police brutality and misconduct often face physical and mental trauma that they need time to recover before bringing their claims. This is why Louisiana extended the time for violence and abuse to 2 or 3 years. Second, you have...
That was in which case?
Pardon?
That was in...
The Louisiana legislature extended the state statute of limitations to 2 and 3 years for child abuse, sexual abuse, and crimes of violence, Your Honor. But that's recognizing a legislative fact that the victims of trauma and abuse need more than 1 year. But they did not do so for the residual statute, knowing that it would apply to Section 1983 plaintiffs.
Go ahead, keep answering.
But second, Your Honor, so in addition to the violence and abuse, which are typical not only of police brutality, but of many types of Section 1983 claims, you also have victims that fear retaliation from the very officers that abuse them, and often are undergoing parallel criminal proceedings where they're concerned that their Section 1983 may be used against them in those proceedings, and they're also in custody. So the injury, the retaliation, and the parallel criminal proceedings are all clear reasons why 1 year is not sufficient. On top of that, you have the factors that the Supreme Court looked at.
To resolve a criminal case before they make a determination about filing a 1983 action?
Well, it's even more complicated than that, Your Honor, under Heck, in terms of they'd have to decide whether or not their case implicates Heck and Wallace, in order whether they have to fly simultaneously, which taxes that defendant individual to having defend criminal proceedings at the same time while they're pursuing their Section 1983 claim, and also to obtain counsel for their civil rights claim. So often they're dealing with both things simultaneously, and if a victim wants to bring a 1983 claim, they're almost always going to need to focus first on defending themselves from criminal proceedings, which takes up time and resources. And another reason I would say, Your Honor, are the very factors that the Supreme Court recognized in Burnett, which apply across the board. Time to find a counsel, often pro bono, as here. Time to conduct investigation before filing a complaint. And indeed, for plaintiffs that have John Doe defendants, under Fifth Circuit precedent, when you substitute an individual for a John Doe, that does not relate back for purpose of statute of limitations. Therefore, if you need discovery in order to find out the names of the officers that abused you, that means you have a matter of months to file in order to get discovery within that 1 year statute of limitations. So there are a number of complicated factors that apply that 1 year is just simply not reasonable and not sufficient time to be consistent with the purpose of deterrence and compensation that Section 1983 was intended to provide.
These are very important arguments. Usually when you've got a Supreme Court saying, we aren't going to reach this question, and that was 30 years ago.
Correct.
You have significant scholarship for supporting authority, especially on these practicalities. You decided what would be, do you have either scholarship or in this record support for those practical obstacles to Brown's situation?
Well, if I can make 2 points, Your Honor. First, the reason it hasn't come up is if I can direct you to tab, I think 6 of the excerpts of record is our 50 state and DC survey. If you notice, the vast majority of states have a 2 or 3, actually over half have 3 years, and 23 states have 2 years. That, we contend, is a sufficient constitutional minimum of time where Mr. Brown's claim would have been timely. So this issue does not come in the vast majority of states. Louisiana is an outlier, and this is the outlier that the Supreme Court had in mind, I think, in its footnote 13. But to your second point of your question, Your Honor, there are a number of scholarship and discussions as cited by our briefs and by the amicus about why it takes time for victims of violence and abuse, and why people that are abused by the police particularly take time to file their
How
claims.
long was Brown incarcerated? He filed about 2 years after the incident.
Under 2 years, Your Honor. Under 2 years, Your Honor.
Just under 2 years?
Correct.
So, and how much of that time was he actually incarcerated?
I think in the record, it's a little silent as to that, but he was in and out of facilities. He also, I think, has suffered severe mental trauma as well from this abuse.
So
But
it's unclear.
it's not explicit in the record, but for a fair amount of time, and it was until he was transferred to a new facility where these officers were not, that he started to recover and be willing to bring this claim. But it took him time to process his trauma, to feel like he wasn't under the thumb of these two officers that now have been indicted and pled guilty by the U.S. Department of Justice to excessive force, criminal violations, throwing over 50 punches, putting him in a corner, hospitalized as a result of these significant injuries. So.
Remind me, in Jones and McDougall, were those courts looking at 1-year general limitations?
And they were looking at a 1 year, Jones and McDougall, Your Honor, I think they were looking at the 1 year, but again, in Alaska and California, there's not the same evidence of discrimination we have here, and those were property cases not involving these same types of practicalities that are so apparent in this heartland of cases for Section 1983.
Can I ask you how you would argue this case on a blank slate? If there were no Supreme Court precedents, all we have is the statute where Congress was silent. How are courts supposed to fill the gap?
On a blank slate, so no Burnett as well, because I think
No Supreme Court precedent, just imagine a hypothetical new statute that simply has no statute of limitations, and therefore.
well, Section 1658, I think, Your Honor, if that applied, it shows that the 4-year residual statute of limitations is what Congress intends where a statute is silent, and that's appropriate here. We discussed under the Burnett factors, but again, your hypothetical, I think that statutory guidance would show that 4 years is generally appropriate. The 1986 1 year was that narrow context in the context of a controversial amendment. So I think 4 years would be where I would look to find those more consistent. And I think you also look at the custom and practice of the states at the time that this was enacted.
Well, I've always found the Supreme Court precedent kind of weird, right? This is a federal statute. You would think the last thing Congress would want is 50 different limitation rules.
I mean, if on a blank slate, you're right. I think the 4-year statute of limitations should apply across the board to Section 1983.
I take it the only reason you're not arguing for the 4-year 1658 is because precedent forecloses it.
I think that's true. I think if I were reading Section 1988 on a clean slate, that first prong where it says you look at the most suitable federal statute of limitations, I think that would direct you to Section 1658, which provides the 4 years, and that would apply across the country. That is how I would argue, Your Honor, in a blank slate. I think that would supply, but I don't think we are able to do that in light of Owens and Wilson, but certainly this court can
I guess
however it
maybe you
sees.
should ask the Supreme Court to get back to the text on
I think this case presents the question that Owens, and it has not been revisited, so I think we would welcome the Supreme Court judgment. I see my time is getting low, but obviously welcome other questions from the panel. But I think, again, the practicalities combined with the discrimination make Louisiana a particular outlier and a particular concern for the inconsistency with federal interest here.
You 28J'd us on his state battery claim?
Yes, so there are several 28J letters, Your Honor. So the most recent one that we submitted were about the fact that the United States Department of Justice has now indicted the appellant Pouncy, and there's a guilty plea with a factual basis for one of the John Doe defendants about this very incident. And so that basically goes to our argument of the Louisiana Article 34, 9310.
State battery claim, was it dismissed as untimely?
It was dismissed as timely, Your Honor, but that was before the facts now show that there is an indictment and guilty plea. And I would say that there are 3 issues with kind of the state law claim. First is we believe that that decision's wrong, and similar to appellants, that their reading of the statute's atextual. It cannot be the case that you have to require a conviction before you can file this claim under Louisiana law. Prosecutors can take up to 6 years to file a claim in Louisiana, and so it can't be that your claim's extinguished after 2 years if there hasn't been a prosecution yet or there's been prosecutorial discretion. But second, even if you take the atextual reading of appellant in the court, now we have the indictment, now we have the guilty plea, so our facts satisfy that case. And third, Your Honor, the fact that Louisiana courts have carved out cases against police from this crime of violence statute just further evidence the discrimination against these types of actions. And as the Supreme Court explained in Wilson, we should not look at the state laws that are analogous where they involve state actions against public officials, as that would be antithesis of what Section 1983 was intended to provide, which is a federal remedy where the state's courts are inadequate.
Can I go back to your invocation of, was it 1658?
Yes,
You know when it was enacted?
in 1990, I believe, Your Honor.
Yeah, that's what I'm seeing. That's after the Supreme Court's precedent.
Correct.
Why can't we apply 16?
I think you can, Your Honor. I think there's two ways to apply 1658. There's the first step of Burnett, which is, again, because 1658 was not available.
Why doesn't this just wipe out? Obviously, if Congress were to amend 1983 directly and say 4 years, we would ignore all the Supreme Court precedent.
Yeah, I think you're right, Your Honor.
Why
I
isn't
think
this the
we
same?
make that argument in our brief that under the first step in Burnett, because the Supreme Court did not have the advantage of 1658, that if they were to decide it now, they could just apply the 4 years across the board. I'll be honest, that has a more far-reaching result in our case, and so I
I'm
think.
just curious why you didn't open with that. Uh-oh. I'm going to assume that's a false alarm.
I think that's.
assured it's a
I think that is a very plausible read, and I think that is also.
You didn't lead with it. I'm not quibbling with your strategy, but I'm just curious. There must,
It is one of. It is.
must be some there must be some hesitation that you think that's not as persuasive as I might think on first blush.
I think it's very persuasive, Your Honor. I'll be honest, I think it's a broader holding, so it's depending on whether this court wants to reach more broadly, but I think it is a more textual reading, so you're correct, Your Honor, it might be.
What makes you think it's a broader reading? Because it applies outside 1983?
No, Your Honor, because it would apply outside of Louisiana, potentially. I think there are different ways you could consider it.
Oh, of course, I see. This would be
Louisiana
placing the
specific.
state-by-state strangeness with a uniform 4-year.
I mean, I think that would be the better result in this case, Your Honor, so if that's more persuasive, then
Seems more
I would
textual.
I would agree it's more textual. And I see my time has expired. Thank you.
Thank you, counsel.
Should we follow the text?
May it please the court?
Should we follow the text?
Your Honor, the text includes a specific provision that would prohibit it from applying to Section 1983 claims.
I'm sorry, pardon my ignorance. You're saying part of 1658 carves out 1983?
It precludes the application of that 4-year time limit to 1983 claims. And I apologize, I don't have the statute printed out in front of me in my notes, but it is, in our briefing, we discussed that extensively.
I remember now, that's right.
My name is David Hemken, and I represent Javaria Pouncy. This case starts with O'Sullivan in 1914 and ends with Owen in 1989. That's my fault. These are both Supreme Court
Give you an extra minute.
It's okay, Your Honor. I was afraid that was going to be mine. O'Sullivan and Owens are both Supreme Court decisions that this court has dutifully followed ever since. According to appellant, every single decision that this court has ever issued that has addressed Section 1983 and Louisiana's 1-year prescriptive period in the context of police misconduct or abuse of force is wrong and should be overturned.
Has any of them, can you point to any of them that addressed footnote 13, that actually addressed the discrimination frustration argument?
You mentioned earlier McDougall and
You
Jones.
said every Fifth Circuit case. Can you point to a single one that's considered this?
The Fifth Circuit has not mentioned 1913.
Issue of first impression for us.
I would disagree with that. If you look at O'Sullivan in 1914, that is actually a case that arose in New Orleans through the Fifth Circuit up to the Supreme Court, and it addressed whether Louisiana's 1-year prescriptive statute would apply to a civil rights violation claim that was decided or that was based on the predecessor to 1983 and 1981 and 85. And the United States Supreme Court correctly decided that Louisiana's 1-year prescriptive period applied. And in that case, interestingly enough, the defendants had been convicted of a federal crime. But when they were sued civilly, because they were not sued within 1 year, the Supreme Court dismissed it as untimely. And while O'Sullivan was from 1914, it was cited with approval by Wilson in 1986, and by Hardin in 1990, or 1989. So O'Sullivan got it right. It's still good law, and it applies, it would apply today, and it's not inconsistent with Owens.
What circuit would you point to that has squarely addressed this issue most compellingly?
The two cases that have addressed footnote 13 were McDougall and Jones. And the footnote 13, I want to take a step back. I think it's being overread. And that's what the court in Woods, now Woods addressed a 2-year provision, but the court in Woods, which I believe was the Seventh Circuit, it addressed footnote 13, and it said it's being overread. If you look at what Justice Rehnquist is really saying, and what the footnote's meaning, is the defendants made two arguments. Argument 1, we win. Argument 2, we win. And the Supreme Court said, because you went under argument 1, we don't need to address argument 2. And it cited Rehnquist's concurring opinion from Burnett. But if you look at that concurring opinion, Justice Rehnquist himself said that he would find a period of at least 1 year reasonable and would be proper. And he, in support of that, he cited Section 1986, which provides a 1-year period. There were questions about the statute that had a 4-year period and whether 1986 existed until there was a reference to the Sherman Amendment. If you go back and read the O'Sullivan case, language regarding a 1-year federal statute of limitations applied to the predecessor of 1986, which back in 1914 was 1981. And so Congress did, in fact, have a 1-year period for a certain subset of claims, and then the 1983 equivalent had no period, and the O'Sullivan court said, we're going to borrow Louisiana's 1-year period, 1-year statute of limitations. The other thing, this court, in applying 1983, and it's done so dozens of times, including in abusive force cases, I believe, Judge Higginson, you were involved in a case, Armstrong v. Serpis, in which it was affirming the Louisiana's 1-year period. Judge Graves in Campos v. City of Nacogdoches, and Judge Ho in Bradley. All three of those cases apply the 1-year period without hesitation. If this court has an obligation to make sure that when it applies a state law statute of limitation, that it doesn't violate federal law. And I believe the fact that this court applied those cases in abusive force situations without hesitation is indicative of the fact that every court that has addressed the 1-year issue has found it was proper, and no courts have found that it's improper.
So you read that footnote to really create a null set, or you would acknowledge at some point, lesser than a year, we'd be inconsistent with deterrence and compensation?
Going back to Burnett, if it was 1 day, that's not enough. If it was 1 week, that's not enough. At some point, it becomes enough. We know that. Now, Mr. Brown is arguing, well, 2 years is enough. Well, 2 years is an arbitrary period, just as 1 year. But the Supreme Court in Wilson and Owens has addressed the fact that a statute of limitations in and of itself is a period that's relatively arbitrary, but the state legislatures have to pick a period that when they apply to all claims that take into account the staleness of the case, loss of evidence, the interest of the litigants.
Yes, but what they're arguing, one aspect of the argument is, let's subdivide. This particular subset of claims is very discrete and particularly likely to involve people that are incarcerated, traumatized, hecked bar problems. They won't file within a year.
If this court were to do that, I believe that would be in direct violation of Wilson and Owens, as well as two different courts decisions from this court, and that is Stinger versus Town of Jonesboro, as well as the King-White case. Wilson and Owens both said we are not going to look at the individual tort. You cannot look at the individual tort. You have to pick one period for all general or residual statute of limitation period and apply it to all 1983 claims, regardless of the type. And then if you go to the King-White case, it involved a very similar situation. You had a defendant that was found guilty or pled guilty of sexual assault of a minor. Texas had a 5-year statute of limitation for that intentional tort. They had a 2-year general. And this court said we cannot apply the 5-year prescriptive period for the intentional tort, because if we did, we'd violate Owens and Wilson. We have to apply the general statute. So even though the plaintiff's claim was untimely under the general statute, and there was a specific intentional tort claim in Texas that addressed the crime at issue, this court said you could not do that. And Judge Higginson, I believe you were not on the main decision, but there was a follow-up decision on that same case that was issued, and it basically restated the holding of the King White case, and that is you cannot look at the specific facts or the specific alleged crime at issue. You have to treat all Section 1983 claims as having equally and as having a single one-year period.
Hypothetically, if a state had a law that said suits against non-state defendants can be brought within 10 years, but for state defendants, it's got to be the one-year general limitation, you'd agree that would be discriminatory?
Absolutely, and there's two instances of that. As a matter of fact, if you go back to the Johnson versus Davis case, that's what happened in Virginia back in 1975. They had one statute that addressed 1983 claims, and they had a longer statute that addressed it with a general or residual statute of limitations. And the Fourth Circuit said, no, that general statute that you've now carved out a subset of things that don't apply to 1983, that would be in violation of federal interest. And I believe that's what Justice Rehnquist was referring to in his concurrence in Burnett. Now, more recently, that was tried in Utah. Utah passed a statute that changed the rules where the general statute was one period, the statute that applied to the 1983 claims was another, and the 11th Circuit said, no, you cannot do that. That would be in violation of the law. In this case, there's been representations that Louisiana has done the same thing. That is absolutely not true. Louisiana has one general tort period that applies to everything, all personal injuries. It applies to medical malpractice, legal malpractice, a lot of complicated cases. Now, they have a separate intentional tort statute, like a lot of cases involving sexual assault, crimes of violence. But that was what was at issue in Owens, where you had a separate intentional tort claim or statute that would govern crimes of violence. And the Supreme Court in Owens said, no, you cannot look to these separate intentional ones. If you did, that would be error. You have to bring it back to the general statute. And so Louisiana has not discriminated against 1983 claims. In 1825, when the Civil Code was first passed, it had 1 year. In 1870, it had 1 year. Now, 1870 was right during the Reconstruction era, when we were under federal occupation, and you had a large percentage of former slaves that were actually on the legislature at that point. And that legislature kept it the same 1 year. And then 100 years later, in the 1980s, the new version of the Civil Code came out, 1 year. It's always been 1 year. It does not discriminate against 1983 claims.
What's the trend in the other states? Have they been since the beginning, or have they been recently with awareness of the 1983 situation expanding towards 3 years?
I have not followed the trend as far as other states.
You agree it's Kentucky and Tennessee that are also the only other two?
Yes, Your Honor, and Puerto Rico. That's the only other two.
Those haven't been challenged on this theory.
Not on the police brutality theory, but they were challenged in McDougall and in Jones. And they analyzed footnote 13 and came up with the same analysis that I'm coming up with, which is they're reading too much into it. 1 year is enough, as evidence, and they point to a bunch of...
Kentucky wasn't issuing Douglas or Jones, right?
Kentucky was not issued. Now, similar to the Fifth Circuit, the First Circuit for Puerto Rico, the Sixth Circuit, and I think one other circuit, have readily applied the 1 year period to 1983 claims, including abuse of force claims. They just haven't done the analysis of footnote 13. But it's very similar to this court, which is there's all this other jurisprudence that would suggest that 1 year is appropriate. There's nothing, it'd be arbitrary to say it's not. And if they were to say it was not, they would have risk violating the Supreme Court precedent of Owens and Wilson.
Can I ask you the same question I asked opposing counsel?
Yes.
Which is, writing on a completely blank slate, no Supreme Court precedent, how would you argue your position?
The Supreme Court got it right. Each state...
I'm asking you to start
If I would do it very similar. I think it was smart for Congress to leave it in the power of the states to determine the statute of limitations, period.
Okay, so you like the 50-state approach.
I do.
That seems atypical, though. I mean, normally, the federal government passes a new cause of action, whatever you want to call it. It's one statute of limitations nationwide. I would think that would be the one thing Congress would definitely not do.
I believe there are other statutes that are kind of similar, such as like Title VII under the EOC, different other type of statutes that will adopt state court rules.
On limitations?
I think the Federal Tort Claims does that, but I have not briefed that issue, Your Honor. The other,
Why should we default to a state-by-state approach?
well, first and foremost, because
Actually asking sort of, a gap, how do courts fill the gaps in this setting?
I understand you're not wanting me to reference precedent, but first and foremost, we should default because of precedents. Second, if you study the Burnett and Owens and Wilson, they talk about the wisdom or the different thoughts of the legislature in coming up with a period that was appropriate. And Wilson had an extended analysis of if you adopt the state general statute that applies to everybody, people with money, people without money, it doesn't matter. It applies to the general, like car wrecks, malpractice, then that could not, by definition, discriminate against 1983 unless there was a carve-out for 1983, and we're not dealing with that here.
So allow me an analogy, and you tell me why this analogy is incorrect, as I'm sure you will. If a statute doesn't have an amount in controversy minimum, courts don't read one into it, right? We just say any amount in controversy is therefore viable. If likewise, if a legislature doesn't impose a statute of limitations, why should a court impose one?
Those issues were addressed in the same decisions about having perpetuate. You have to put in. There's an interest in having it into litigation. If you had an unlimited time,
Right, and that's something that the legislature can impose.
and so we couldn't
The
have.
legislature is upset with the absurdly stale claims, which a policy argument I certainly could get. The legislature is fully empowered to write causes of limitations, just like it did, for example, in 1658. I realize 1658 is only applicable for later cause of action, but the point is legislatures can step in.
Well, I think that goes to the underlying point: is this issue is properly before Congress, not this court, in my opinion.
I agree, but how does that cut?
I'm sorry. How does it
How
work?
does that cut? Congress can step in to add a limitations period, to make it longer, to make it shorter. The fact that there is no limitations, why does that default to 1 year or 3 years or indeed any years? What's the argument for choosing one default rule over another, one gap filler?
In the interest of uniformity within a state, you should pick. The court wanted uniformity and consistency, which is why the Owens.
Right, but you said 50 states. That's the opposite of uniformity.
I
I actually agree with you. Uniformity you would think the default at least would be, I assume you want a one rule. But you were saying, no, actually the default should be some sort of state-by-state differential.
I mean, it's within Congress's prerogative to do that. And when they passed the predecessor to 1983, Louisiana had a 1-year period, and they did not put a specific period to suggest it should be something else. O'Sullivan came out. Congress has amended these statutes. They've known about the 1-year period. It's been 200 years we've had 1-year period. They have had multiple opportunities. If they disagreed or thought that Louisiana got it wrong, they could have stepped in and clarified or extended it. It should be a longer period. I don't have the opinion in front of me, but there's Supreme Court, I believe Fifth Circuit precedent or opinions that would suggest if Congress has if they know about a law and they know how it's being applied based on the Supreme Court ruling, and they don't change it, that's at least a tacit acceptance of that law. And here, Congress has not changed the 1 year, or 1983, in light of its knowledge of the fact that Louisiana has a 1-year general prescriptive period. Now, one other thing, just to kind of address a little bit of some of the policy argument that's being raised, well, actually two if I have time. One is some of these concerns that have been raised, they're addressed via contra non volentem or equitable tolling to the extent they apply. Now, they don't apply here, they haven't been pled here, they weren't raised below, and they're not raised before this court. But in Hardin, which is a Supreme Court decision, the court found that Michigan had an equitable tolling period, and the Sixth Circuit had tried to say, well, you can't apply the equitable tolling period to a 1983 claim. And the Supreme Court in Hardin said, no, you do get to apply the equitable tolling period. Whatever the general rule is for the statute, including its equitable tolling, you apply that to 1983 claims. This court has recognized the concept of contra non or volentem or equitable tolling with respect to 1983 claims as well. And so to the extent that there's this argument that certain people may have injury or certain things that legally would fit Louisiana's definition of contra non volentem and would prevent them from timely filing suit, well, that's already addressed in the current statute and the current law. Having this court jurisprudentially create a 4-year period or a 2-year period for a subset or a carve-out of claims, that would be contrary to precedent, and it would be the first time that such ruling has ever been issued. The other thing is there was reference to Mr. Pouncy's condition. I don't believe that's in the record. And so I hesitate to go there because this is not also in the record. But he had an attorney prior to the 1 year period and did not file suit. So this argument that he was incarcerated, but we don't know how long he's incarcerated, that somehow prevented him. That's not before this court. But irrespective of that, it doesn't tell the whole story. Another case that I failed to mention earlier is a Supreme Court case from 1975 called Johnson versus Railway Express. And in that court, the Supreme Court also affirmed a 1 year prescriptive period on a 1981 claim. But it was a civil rights claim, and in that case, the plaintiff had filed administrative proceedings before the EEOC and thought that was enough to toll and didn't need to actually file a civil rights claim. And the United States Supreme Court dismissed his claim as untimely based on the 1 year period without question of whether 1 year would have been contrary to the federal interests involved with civil rights or would have been unreasonably short. I'm coming up on the end of my time. The last point I would like to make is the argument that we should have a carve-out for these special claims involving police brutality or abuse of force. That would inflict the exact type of uncertainty and the exact type of confusion that Wilson and Owens specifically addressed and tried to put an end to. So we respectfully request that this court affirm the district court and dismiss or uphold the dismissal of Mr. Brown's claims as untimely. I'd still have 1 minute and 40 seconds. One more thing. The state law claim. One, Mr. Pouncy has pled not guilty to it. Two, the district court dismissed it without prejudice. It's been refiled back in state court. That's a state law issue that's being handled by the state court. Regardless of the outcome of that, it has no effect on, we know this from Owens and Wilson and King White. Regardless of the outcome of the state law case, that has no effect on the federal issue and what statute of limitations period applies to a federal claim. Thank you.
Thank you, counsel. Rebuttal.
Okay, Your Honor, just a few quick points. First, appellant relies heavily on the O'Sullivan case, which was from 1914 before the Supreme Court. That involved the question of whether the Louisiana statute of limitations involved penalty or damages. It did not address the issue that the Supreme Court reserved in Owens, or else why else would Owens have reserved that very question? Second, the appellant referred to the equitable tolling.
You mean opposing counsel?
Opposing counsel, thank you, opposing counsel, referred to equitable tolling being a remedy here, but actually the cases that he referred to, Armstrong, Bradley, Diaz, and Francois, demonstrate that Louisiana's version of equitable tolling does not apply based on the practicalities that we've raised in our briefs. And those cases denied contra non-volentem where there were injuries, where there was fear of retaliation, where there were parallel criminal proceedings. It's a very narrow concept in Louisiana law, which is just another reason why the 1 year is just not enough here in these circumstances.
Hardin, too.
Pardon?
Hardin, were you going to get to Hardin?
Oh, Hardin v. Straub, I think, actually cuts in our favor, Your Honor, because there the Supreme Court recognized the concern that we found in terms of inmates being loath to bring claims against their officers that they're in custody. And so that recognized that concern is consistent with 1983. And if my client were located in Michigan, he would have had the opportunity to litigate his claim based under Michigan, but Louisiana is particularly hostile to these claims and provides neither tolling nor a sufficiently long statute of limitations to bring that claim. And I'd also like to get back to Your Honor's question about Section 1988. Looking back at that language of the statute, it asks to be exercised in conformity with the laws of the United States so far as such laws are suitable to carry the same effect. It does not work, so I think under the plain language of Section 1988, one can apply Section 1658 as a more suitable statute of limitations for Section 1983 claims. And I think that's consistent with Supreme Court precedent. As you recognize, this statute came into effect after the Supreme Court decision in Owens. It provides a more uniform standard. But I think we prevail in either case. You can either apply Section 6058 under the first step of Burnett in Section 1988, so it's the first place you look. But at the last step, the third step of Burnett and Section 1988, you always have the fail-safe of if a state law is inconsistent with the federal rights, you need a more appropriate option. And that's where we are here. So under the third step, because Louisiana 1 year is just too short and discriminatory, you need to look somewhere else, which you can either look to Section 1658 for 4 years, or what would be analogous under the state law of 2 years, both of which are more consistent with what the majority of the other states in the United States have for these very important federal constitutional civil rights claims.
Can I go back to my textualist question on a blank slate? You answered 1658. Obviously, 1658 only applies to subsequent statutes. So let me ask my question again. If we're on a blank slate, no Supreme Court precedent, how would you argue this?
Well, I think Your Honor is correct that 1658 does not apply of its own force. But under Section 1988, which is saying a gap filler, so what do we do because Section 1983 doesn't have a statute of limitations? There's really two options. There's no statute of limitations, which is what the Supreme Court held in Occidental for EEOC claims, where you could say there was no statute of limitations, or you can look to related federal statutes, which the Supreme Court did in Del Costello. So here, under the Section 1988 framework, we're looking at Section 58 as an analogy, as a reference point, not applying it of its own force. And that's where you can get to the 4 years, which is more appropriate, consistent with congressional intent of what to do when there is that gap in federal law, which we have in Section 1983. And you don't need to resort to the Supreme Court patchwork of 50 states, although we contend even if you do, you still need to look elsewhere because 1 year is simply too short and inconsistent with federal interests. And if there are no further questions, Your Honor, we would ask for you to reverse the decision below and hold that the 1 year statute of limitations in Louisiana should not be applied to Mr. Brown's claim. Thank you.
Thank you, counsel. The court will take this matter under advisement. Our next case is called